All right, can we get started? So welcome to Legal Liabilities presentation from Franklin County Prosecutor's Office. Just a little bit of background. So we've been working extensively with Prosecutor's Office over the last year around some of our policies. They certainly helped us in the development of our field, transport, and search policies. They worked with us when we met with the criminal committee to go through those policies. They're going to continue to help us when we submit the use of force and arrest policy. So the nice thing about this collaboration with the prosecutor's office is developing those relationships with our external stakeholders. That's been a goal of ours in the last 2 years, and I think we've done a good job of working together, not only working with Dan and Scott, but also working with Nancy Moore, Ron O'Brien, and various different factions within the prosecutor's office. The legal liabilities presentation is something that we've wanted to do for quite some time. It is also part of some of our training requirements for our new staff that come on board. So those of you who have been anxiously waiting for this presentation so you can get out in the field shortly thereafter, that will happen. There were several of them in the last session. So the prosecutor's office, if I am correct, if we had any civil liability issues or if we erred in some fashion or if there's some representation, it is the prosecutor's office that represents our department, correct?
Yes.
Yeah. So again, it's another good reason why to have good relationships with the prosecutor's office. So I'm not going to belabor any more of this. I want to thank Scott and Dan and Jason for giving us the presentation today. Please feel free to ask any questions. And then at the end, there is training feedback forms, so please fill those out so that we can see what we need to do better or even provide some additional information moving forward. Sound good? Thank you. Now you can talk.
All right, good afternoon. For those of you who don't know me, my name's Dan Cable. I'm with the Franklin County Prosecutor's Office. I've been there for 100 years. Scott Sheets and Jason Wagner with our office as well in the Civil Division. What I'm going to do this afternoon is just do some basic, maybe rehash, that doesn't sound good, refamiliarize you with Fourth Amendment issues as it relates to searching folks' houses and that kind of stuff. A lot of the things that you deal with will involve the consent, obviously, of the probationer, and that's going to carry the day for you, but there are other times where you will come across things where you need to fall back on what I would call standard Fourth Amendment analysis on whether or not you're able to search somebody, seize somebody, arrest somebody. I teach this line of material at Ohio University as adjunct professor, and I've also done the training, the refamiliarization with the Franklin County Sheriff's Department and some other local police agencies here in Franklin County. So what I've done now and what Lori I think has asked me to do is to kind of take that and try to make it applicable to you as much as possible. You'll be sitting here, I know, wondering, we got consent, what do I have to know the Fourth Amendment for? And to a large degree, that's right. But there are going to be times, especially when we get in situations where you don't, maybe the person shares a house with somebody or parent-child type situation where you're going to find yourself potentially needing to fall back on standard probable cause definitions, standard search incident valid arrest definitions, those kind of things. So that's what I'm going to do, hopefully in fairly short order, and then hand over the civil liabilities as it relates to things like use of force and those kind of things over to, I believe Jason will be doing it this afternoon. So that's the plan. So with that said, we'll start right here. This is where everything comes from. I put this up here for a couple reasons. One, because if you haven't had any constitutional law classes or issues or refreshers in the last 15, 20 years, like a lot of folks haven't, it's up here for a couple reasons. One, if you look at line 3, the last 2 words is protects you against unreasonable searches, protects folks against unreasonable searches. That's a very important phrase because, as you're going to find out in the next 2 hours, with the stuff I give you, with the stuff Jason gives you, the word reasonable carries the day when it relates to what the Supreme Court's going to say as far as did you do your job appropriately or did you not. We're going to give you a lot of case law, a lot of different things, but in the end, you'll find out that Supreme Court, district courts, trial courts, certainly, you're aware, as you sit in on Dispo Day and listen to them do things that make your brain spin, sometimes they interpret things how they want. And so we need to have a working understanding of what reasonable is and how it applies. The other reason I put this up here is to remind you that you're the government. And so, you know, the Fourth Amendment, the First Amendment, the Second Amendment, all these amendments, the Bill of Rights, were not written to protect people from burglars, weren't written to protect people from bad guys, weren't written to protect citizens from people who might violate them. They were written to protect citizens from you and me. In the constitutional scheme, we're the bad guys. That's why these things are here, to protect your average citizen from you and me. So you have to know that going in. So when if you're sitting on a witness stand at some point trying to explain why you did what you did, you can't just say because I'm the law and I do it. That's not how it works. This is how we've always done it. What you have to understand is you start from having to explain why you violated some citizens' rights and why you were allowed to do that. And we'll go in and talk about why we're allowed to do that and why we're required to do that. But you have to at least know the playing field you're on and always know that, man, all of these types of situations, the fallback answer is to get a warrant. If you have questions, get a warrant. That's where we're supposed to start. Right? Even you guys. That's where you're supposed to start. That's where the Constitution contemplates that you will start, with a warrant. You never hardly ever get warrants, right? That's because the Supreme Court said here's the exceptions, and we'll go over a couple of them, of why you don't have to. But you need to know how you got there so that you can sound articulate in front of a judge, and I'll explain why that's very important down the road. All of these issues, as it relates to searches, seizures, probationers or their roommates, or seizing things from their house, come out of this Fourth Amendment and what we call a reasonable expectation of privacy. Again, here's the word reasonableness. It's what somebody anticipates they're doing when they act a certain way. So for instance, if they're out driving in a car, they have a lower expectation of privacy than if they're in their home. Same with you against the government. If you're in your home, you've put up 4 walls, you've got a lock on your door, you're telling the world what's in here is private to me. If you're in a car, you're saying, hey, look at me, I've got a new Mustang, right? And there's very little in the way of privacy. So that it ties to the person, what they expect, and you have to be aware of that. Even with consent cases, you can go too far. Things can be unreasonable. And so you have to understand what it is they're trying to do and what it is you can do. This is the definition of probable cause. Where the facts and circumstances within the officer's knowledge in which they have reasonable, trustworthy information sufficient in themselves to warrant a person reasonable caution in the belief that an offense has been or is being committed. Sounds like it was written by a lawyer. It's because it was written by a lawyer. You guys are going to get some legal case law today. And sadly, everything you do and all the rules you have to follow were written by lawyers. I hate sounding like a lawyer. I intentionally do not use Latin terms. It's a dead language for a reason, as I figure it. But you have to understand some of this legalese. So, what's this mean? If you were to explain probable cause to somebody, you're looking at the definition, right? Y'all are sitting here looking at the definition. Somebody tell me what it means. Somebody needs to have that app where crickets come on their phone. Does anybody got that? They can just play the cricket apps. Anyone? You don't have to be a lawyer. Anybody wants to try?
It's a reasonable officer at the scene who would believe that an offense has been committed.
Okay, that's almost exactly what's on. So I give you points for trying. Right? Let me ask you this. If I gave you 0 to 100, let's number it, even though the Supreme Court says we can't number it. Let's number it. 0 meaning perfectly innocent, 100 meaning dead bang guilty, caught red-handed. Between those two, what percentage gets you to probable cause, where you can arrest or search?
51%.
51? Why? What'd you say?
2/3.
2/3?
Yeah.
It's closer to 51. It's not 51. In fact, like I said, it's not any number. It's what's, this is going to shock you, it's what's reasonable, right? You're going to tell your story, you're going to articulate your story, and it's what's reasonable to the judge. But the common way we describe probable cause is that it's more probable than not. And I found when I teach police officers or upcoming police officers, soon-to-be police officers, this is a good way to handle it. I think get your brain around it. Is that when you ask yourself, has this probationer violated his terms of immunity and control? If we're on a probable cause standard, you would word that in, is it more likely than not he did? And that gets you to kind of like 50 plus, right? Something around in there. So for probable cause, that's what you need. This second phrase here is how the courts view whether or not probable cause or reasonable suspicion, which is what we're going to talk about in your cases, whether it's viewed reasonably, or is an acronym for ordinary, reasonable, prudent, and then it can stand for probation officer, police officer, or person, depending upon which part of the law. So an ordinary, reasonable, prudent person, if their actions, not, and this is the kind of hard part to understand, not your actions, but an ordinary person who's in your position. Does that make any sense? I've got one example to give you that I can do. Let's pretend that I'm a police officer. There's a burning building and you're walking down the street coming out of it, right? And it's a real gun, not my finger. I've got some questions for you about that burning building. I know you're walking away from it that I'd like for you to answer. First of all, you're absolutely free to go, sir, anytime you want. Would you like to answer some questions about that burning building? Is he free to go?
I would say,
Yeah.
I'd say he's
No.
innocent.
Reasonable person would not feel they're free to go, right? So, when you get on the stand and say, well, of course what he told me is admissible. I didn't have to read him Miranda rights. He went in custody. He was absolutely free to go. That's not how the Supreme Court's going to analyze this case. What they're going to analyze is what would an ordinary, reasonably prudent probation officer be trying to accomplish with this? If you were doing this, what are you trying to do?
Trying to elicit information. I've got to seize this person.
You're trying to detain. Right. That's what this means to the ordinary, reasonable person. Just because the actual person doing it is a complete idiot doesn't mean that we now get that evidence, right? Because he had an honest belief that he was telling the truth when he said he's free to go. That's not reasonable. That's not what it is. So do you see what I'm saying? It's your actions will be judged by what a prudent probation officer would be doing in that situation. A lot of it's common sense. This morning when Scott was given the presentation on legal liabilities, he said something that was profound. I don't know that he knew it at the time, but it's profound in its simplicity. If you do what's right, use your common sense and do what's right for the right reason, you'd be surprised how many times that fits squarely right where we need it to fit in constitutional law. The beauty about not having to go through law school to read all that law and to write sentences like that is that to do what we do on a daily basis, the main thing we need is common sense more than anything. So if you're doing the right thing, if you're searching the right person, if you're acting appropriately with folks, somebody like Scott and Jason are going to be able to defend you much easier down the road if something goes south. You were either a good probation officer when you came out of kindergarten or you were not. Right? If your report card came back and you said, "Here, Mommy," and it says, "Plays well with others," right? You're a good trial attorney, you're a good probation officer, you're a good cop, right there. Everything since then, I don't know if you've noticed this, but everything since kindergarten is just the book learning that you have to do to get the little piece of paper to let you do the job. You had it. You had it in kindergarten. Don't forget that. That's all it requires. Now, the next thing I want to talk about, and this is really where it applies to you more than anything, is a step down from probable cause is a thing we call reasonable suspicion. The definition that I've put on the board for reasonable suspicion comes from Terry versus Ohio, which I imagine a lot of you know is the case that allows us to detain a person briefly to find out what's going on, and if we suspect weapons, pat them down without having probable cause to charge them for a crime. It allows us, it's that kind of, hold on a minute, let's see what we got, and you're allowed to detain them. Before 1968, you weren't allowed to do that. Of course, back then, we also had, I don't know if anybody was old enough, I don't remember, I was 2 in 1968, but back then you also had a lot of things like suspicious person criminal charges on the books. You know, that's how we addressed, but Terry said you don't need to make those things up, you're allowed to stop. And this says you can detain somebody based on your reasonable articulable suspicion that criminal activity is being planned or is afoot. This is important for a couple reasons. The whole issue of them signing consent so that they don't go to prison, right? Which means you can come into my house. Your policy, and as Lori was mentioning, we've gone through this, we've been working on this, and she gives us more credit. Her and Susan and a few others of you have been tirelessly working on this, and they're doing a great job for you guys. And let me also say before I get too far along, a couple things. One, we're here to tell you kind of the way these presentations play out. They play out to teach you things not to do. So you get a lot of like horror stories, especially with their stuff. You'll get some horror stories. And it's really unfair to you because, and I'm specifically referring to the Franklin County Adult Probation Department. You guys, we've never had a problem that I'm aware of. You guys do your job. Yeah, I guess, well, you guys do your job that we've been able to see. You do your job well. And that's both from the folks that have to defend you over civil division, and guys like me and ladies in my line of work who sit elbow to elbow with you during dispo days and talk to judges about these yahoos that you guys are charged to look over. You guys generally do your job very well, and we appreciate that. And so when we get into these horror stories, we're not trying to say, you know, you guys are all asses, so quit being an ass. Just remember that, because from now on, that's how it's going to sound. The other thing that I want to make very clear is that don't take anything that comes out of my mouth and go to Lori with it and say, well, I can do this because Cable said I could. If it's against your policy, or if here's what I'm saying, your policy trumps. Lori trumps Cable. Got it? Lori trumps Sheets and Wagner. Lori trumps, whatever your policy is your policy. And they've done a lot of work, and we shouldn't be telling you. I don't think we do tell you anything that's different than your policy. But in the case that something comes up, I don't need Lori calling me, screaming at me because you think I've told you something that she doesn't want you to do. But your policy says for that search, even though they signed consent, if you're going to do a search other than just you're out on a field visit, if you want to do a search, you need reasonable suspicion, you need reasonable grounds to do it. And so the best definition of that comes from Terry. Again, it goes back to the Fourth Amendment, reasonableness standard of being able to search, or in essence, do a warrantless search. And again, you can always get a warrant. This is less than probable cause. So we talked about numbers 50, 51, more probable than not. Reasonable suspicion is something less than that. So you guys, because they're probationers and enjoy a lower level of expectation of privacy, right? That expectation of privacy I put up there was for your average citizens. Probationers, by legal definition, enjoy a lesser expectation of privacy than your average citizen. So that's why we don't need full-blown probable cause, we need reasonable suspicion. So what makes something reasonable and what doesn't? You're going to hear this phrase, if you haven't heard it before, called totality of the circumstances. And it means exactly what it sounds like. A lot of times words have meaning, it turns out, in law. And totality of the circumstances means just that, everything you know. Everything that comes in. So a neighbor calls and says, you got a probationer out here and he's got a grow facility in his basement. Can you use that? Absolutely, right? Now, if the ex-wife calls Now you got something else, you know what I'm saying? Reasonable, right? Ex-wife calls and says, your probationer has a, and they're in the middle of a custody battle and there's nothing more that she would love than to have him kicked out of his house and rearrested for something. Your ears should pop up at that point. But a neighbor calls, who you've known in the past to be solid, you probably are already there. So it just depends on the situation, whatever's reasonable at the time. The one thing I do want to make sure, because I think it's non-intuitive for you when you're talking about sitting in front of a judge explaining why you did this, why we found this evidence, how we got this evidence, whether it's to revoke the probation or to file new charges, or file charges against somebody that isn't the probationer that you found evidence on, which happens from time to time. This last thing is more important than you might think up here. Who you are matters as much as what you did. And I know we say a lot of times, well, the law, the black letter is the law, but that's not what the Fourth Amendment is not about black letter or nothing. The word reasonableness by itself tells you, because however many folks are in this room is however many different definitions of reasonable I would get if you were forced to write it down on a piece of paper, which I'm not going to do. Right? So Fourth Amendment and these legal liability things and the use of force under the Fourth Amendment are all just taken at the time, what's reasonable at the time. You, with a lot of experience, I've done this 100 times, I know what a drug deal looks like, I know what marijuana smells like. I've known this guy, he violates, he tries to throw a brick at me every time I come through the, you know what I'm saying? Versus somebody just comes in and says, I've been on the job for 2 months and it sounded to me like this might be bad. You see the difference? It could be the same exact set of facts, but what wins it for a judge is you knowing what you're doing. You being able to convince the judge that you know what you're doing. The judges are interested in not being overturned, right? That's one of their big interests. And if you can basically set up on that witness stand and say, I got you, the Supreme Court says that can factor in to reasonableness. So don't be afraid to tout yourself a little bit. I know most of you don't want to do that, but don't be afraid to tout when we ask you on the stand what's your experience. Tell us everything. The more you've done, the more experienced you are, the more you've dealt with this kind of situation, legally matters when it gets up the road. All right, I told you there were exceptions to the search warrant requirement, and that's why I put the Fourth Amendment up there. Here are several of them. We are not going to go through each one of them because most of them don't apply to what you guys do. But here are the generally recognized exceptions to the search warrant requirement. So if you don't have a warrant, you can still seize something or somebody. And by the way, just point of clarity, that Fourth Amendment search and seizure includes arrests. Because what an arrest is legally is a Fourth Amendment seizure of a body, of some body. Right? So we mostly think of search and seizures of grabbing cocaine, grabbing guns, grabbing contraband, grabbing things off computers. It also means grabbing a human body. And then we just call that an arrest. We use a different term for it, but it's all the same under the Fourth Amendment. And you have to have exceptions if you're not going to get a warrant. Remember, we start with a warrant. This first one here we will talk about. It stands for search incident to a valid arrest. You may have heard it say search incident to a legal arrest. Same thing, SIVA. It means a valid arrest. So if you arrest somebody, you've got your reasonable suspicion that they violated their terms of probation, right? You arrest them. Where can you search them? Where you find them, right? So what about after you've already handcuffed them and taken them out? Do you still get where they were sitting? Yeah. I'm seeing nods. Yeah. I'm seeing completely blank stares. I'm seeing people checked out. Some of you. Yeah. The Supreme Court says you get where they were when you just had the arrest authority. You can go back. So if they're sitting on the couch, you can search that couch around them. Certainly anything that's on them, right? Their pockets, thing. And don't get tripped up on this. If you're ever asked, because defense attorneys like to do this kind of thing, try to get you tripped up on where you are in the landscape of the Constitution. Remember that by definition, when we get to search incident to a valid arrest, God, now I got to start all over. When we get to search incident to a valid arrest, remember all that stuff we talked about reasonableness? You've already played that card. you don't need it again, right? The arrest has to be reasonable. If the arrest is reasonable, this stuff, you don't need reason one. If the arrest is reasonable, you're arresting them. You get the pockets, you get the shoes, you get their clothes, you get where they're around, the coffee table they could have reached in, the glove box if they're in the car. You don't have to get on the stand and say, well, defense attorney says, well, what reason did you have to reach into his pocket and find that cocaine? You didn't think he had cocaine, and you're like, oh God, I didn't have it. Cable said it has to have some reason to articulate. No, you're past that. Once the arrest is made, search incident to a valid arrest gives you the authority to get everything that's around them, regardless of a reason. This just goes to tell you, give you a case, and we put these cases up, and I know Scott and Jason have some more. I'm not going to go through Maryland versus Bowie, but I think we're going to end up shipping the PowerPoints to Lori. So if you ever have questions on any of this stuff, there's a case you can go look at, right? If you ever wonder how much of a house do I get under a search incident to a valid arrest? What rooms do I get? Generally it's where somebody could be that could hurt you, right? If it's in another room and it's small and could hold a gun, no, right? Because it's like the bumper sticker. Guns don't kill people. People kill people. So a gun in a box in another room is of no concern to you. But a closet is, right? Adjacent closet or somewhere, because there could be a person in there. But we put these cases up so that if you want to go over them or satisfy any further curiosity, they're up there.
But with that last
Yes.
statement you made, you're just talking about like when we initially go in and we're like clearing the house.
Mhm.
It's not if we're looking for a gun.
Right.
Okay.
Right. Now, if you're looking for a gun, then their consent is typically going to have been good enough for that. Assume you have a reason to believe. You have to explain why you think there's a gun
What if there's information that there's a gun in the safe?
that it's a gun in a safe. Well, again, if you've gone in to arrest them and you're just doing your protective sweep, then that's not. But if you're searching pursuant to their consent and you have reason to believe, then you can go and get the safe. If there's ever a question, you can always get a warrant. How many of you have ever gotten a warrant, by the way? Okay. How did it come up?
I've never gotten one in this county.
Okay.
I have in the other county I live.
Okay. How did it come up?
Most of my warrants were for mental health clients.
Okay.
That were in GRI.
Gotcha. Okay. Well, and that goes to this consent that we're talking about, that they sign, and we'll talk about consent in a minute. There's some things that they can consent, but, if they're mentally ill, they don't speak the language, or if they're, some other problems. Yes.
Well, I was going to add in here, I talked about later, the consent, is that the general conditions and supervisions that we signed for
Mhm.
J1, is that still valid?
Mhm.
2 years, 3 years?
Mhm. Mhm. I'm guessing that if you revoke them, send them to prison, and then let them back out, you probably would have to do it again. Plainview is another one that comes up from time to time, and this is both for you walk in on a field visit and there's something that's clearly contraband, or there's something that now what do we do? And I think we've discussed that before in the policies about calling law enforcement or maybe getting it yourself, securing it. As far as do I secure, let's say you walk in, you're doing a field visit, and you walk in and he's talking to you in the living room, and on the table is a baggie of what clearly to be powdered cocaine. What do you guys do? Taste it. Yeah, like the movies. Right? I keep forgetting we're being recorded. Edit button is on. Bad news. What do you do?
Me personally, I would probably detain that individual and assess from there.
Okay.
What most people do is walk away.
Okay. What if you're walking away and leaving 9-year-old kids? See how Do you see why reasonable works? And they talk about it as well. A lot of law enforcement folks, you guys, cops, prosecutors, we all like bright line rules. Like if this, then that. You know, we're like the computer folks. And we love that kind of stuff. And you just don't get it in our jobs. You just don't. But that's, you see what I'm saying? That's the reason. You don't want a bright line test because it handcuffs you. Because if it is, you can never get it, and you're watching a toddler crawl over to it, then that's a horrible bright line test, right? It's what's reasonable. So what do you do then? You're leaving a 9-year-old with a bag of cocaine? You are, aren't you? She's gonna hit you in the back of the head.
She's not gonna leave. No, but then you gotta like step out and call the manager and see what you got. It's just a lot of.
Well, you follow the first answer, you follow your policy.
Yeah.
You follow whatever Lori tells you to do. But if there's something extenuating, I think you've got room for, and even in your policy, for extenuating circumstances to call folks, get some idea of what's going on. But you certainly don't just walk away from things. The one thing I will say about this, back into the words have meaning category, the case that comes up a lot in the plain view stuff is where this was not probation, but it was police go to a shots fired into an apartment complex, and they get there and there's a bullet hole in the door. Nobody answers, so they go through because it's emergency circumstances. We'll talk about that a little bit in a second. Nobody's there. Squalid apartment, which means squalid means worse than just messy. Squalid means like you see on the TV show Hoarders. You ever see that? Like there's like carcasses of animals and stuff lying around, you know, feces. Except for this brand new shiny stereo in a corner, right? You guys are law enforcement. What's that likely to be? Stolen, right? Doesn't take long. See, this is why personal training and experience matter. And of course it is. Of course it's stolen, right? So they go over there, they move it, they look at the serial number, they call out to the Walmart. Yep, that's one of the ones we got stolen. We lost that case. We lost the evidence. You know why? What part of that violates one of these three rules? It's law school now. You guys didn't know that, did you? When you came in, you were going to get a law school exam. You have to have all three of those.
Oh, you have to have all three?
You have to have all three. So where did we fail? Which one of those failed in my scenario? Number 3? Why?
Serial number?
What about the serial number?
Wasn't. You had to look for the serial number.
Here it is. Words have meaning. If it were immediately apparent, what wouldn't you have had to do? Move it, look at the serial number, and call the Walmart. Words have meaning. So when you're in a plain view situation now, this is real easy if that's a baggie of cocaine. It's immediately apparent. You know, there are things that are evidence and things that are contraband, right? Contraband is cocaine, heroin, things that are always illegal all the time. Then there's evidence, which are things like guns and bats and you know, you guys have seen it all like me. You know, the guy robbing frozen hamburger out of the freezer. You know, that turns out to be a weapon. And you know, things like that. That now it, you know, maybe plain view, maybe not. If it's a gun and you're probationer, that's a violation. Then that's immediately apparent, right? Regardless of whether that gun's stolen or not, if his condition is can't have a gun, well, now a gun becomes just like contraband to him. And so your plain view, even, you know, and it would give you reason to yank him, even if it turns out it wasn't his gun, right? Here's the one we talk about a lot because this is the one you primarily use. And consent, the only requirement is given voluntarily, and that's what they do typically when they sign off on your general conditions. Like I said, the only thing you have to worry about if you're out in the field and consent becomes an issue, like with a parent or a roommate or something like that, is that the only requirement is it's given voluntarily. So to use my thing again, you know, you carefully search your son's bed. That's not consent, right? Because that's not. He's going to say yes. You've taken his choice away from him. I guess I shouldn't put that in here. Maybe he's going to bow up and kick my ass. I don't know, but he's probably going to say yes. And you've taken his his choice, his voluntary choice away from him at that point. And again, not that you'll need this too much, but there's no requirement that you give like the Miranda warnings for consent. You don't have to say, you have the right to withdraw consent, consent's a license, you can only give me consent to search part of the house if you want to, or the whole, which is all true. Do you understand? Are you willing to waive your, you don't have to do any of that. Just, can I come in if they say yep, or give you the Olay or whatever symbol or however, what's reasonable, right? Whatever's reasonable. Can it, you know, if you say, can I come in, and they open the door and go like this, is that reasonable to believe they've consented? Sure. That's what you do when you let somebody in the house. You don't need to say it. I go back to this because, again, consent and whether it's voluntary is all within what's within your scope of knowledge, your range of experience as a personal probation officer. It will be analyzed by the reasonable probation officer, and the reasonable probation officer who's in your position with your experience, your level of knowledge, your familiarity with these kinds of cases. Some of you work sex cases, some of you work narcotics cases, some of you, we have different dockets, obviously, and you're going to have a greater ability to have what you do be seen as reasonable in that field than somebody else. Doesn't mean that somebody who isn't in that unit can't act reasonable, but it's just another pitch if you have more experience on that. Emergency circumstances. The only reason I bring this up, again, you make a field visit. The emergency circumstances that we all are familiar with and we all know and jump to the front of your head are gunshots, woman screaming in the next room, kid jumping out window, all those things that are clearly emergencies. That's common sense. You're right about that. It's the same in the legal sense as it is a common sense. But there's this one that a lot of people don't automatically or don't intuitively know, and that is the destruction of evidence is an emergency circumstance. So if you go in and you hear somebody flushing the cocaine down the drain, you can go in and get it. If they're starting to eat the pills, and they'll talk about that, what can you do, what kind of force can you use if they're starting to eat the pills? And it turns out it's pretty good for you guys because it's viewed as an emergency circumstance. Whenever you can get on the stand and say, I acted under the emergency, or it's called exigent legally, but emergency circumstance rule, you're going to get a lot because obviously it's emergency. And we're expected, and you're expected to do more than you might normally. And then this one is where we get caught up a little bit. That boyfriend or girlfriend that you're living with, and everything's really great right now, and you don't know that it's about to end, and she does, and the police come over, can I search? And she goes, hell yeah, go get him, right? And you're just at the McDonald's, trying to have breakfast, and so that you have to have joint authority. If you're in a situation where this person has a roommate or something like that, as long as they have the authority, the roommate can give you authority to go into common places, things like that. The probationer can give you authority to go into common places, but not necessarily places that are the lone province of the roommate or somebody else in that category. Certainly landlord-tenant kind of thing. There's a whole different spin on it. And again, it's common sense and reasonableness. So if you go into a house and then Sally Bob is there and opens the door and says, yeah, I live here too, you can come in, and you have no reason to disbelieve her, you can go in. But if you know Sally Bob and you know she doesn't really live there and she just wants to get her brother in trouble, you can't, you know what I'm saying? That, do you see where you change it? It's not reasonable any longer for you to take the exact same words that she said, and when you could go because you didn't know who she was, she can say the exact same words, and now it's not reasonable to search because you do know who she is. Again, it's what's within your personal realm of knowledge. Somebody asked in the last session about what if you've got equal people. And has this ever come up, a wife or a husband, one saying, come in and one saying no? You guys ever run into that? Okay, good, because right now it's not good for us. If somebody who has authority can say no. All right, we'll see how well you're doing. Bradley Andre, who is your probationer. was visited by 2 probation officers and local law enforcement after reports that Andre had violated his probation by having firearms and marijuana. After consent to search the home was given, the main and upper floors were searched. Even though you detected a strong odor of marijuana, you didn't find any. You then went to the basement door to search, but it was locked by a key and a number pad activated bolt lock. And just for additional reference, this is not like 483.5. There's no outside entrance to this basement door. So you have to come through your probationer's house to get to this basement door, which is locked. Your probationer tells you that he's renting the basement to a guy named Norman and another individual, claiming that he did not have a key, nor did your probationer know the combination. He did tell you, however, that he keeps stuff in the basement, including a gun safe, which you know to be, if there's a gun in it, a violation of his probation. During the discussion, the second renter comes in, admits that there's marijuana in there. Yep, that's what you smell, but no, you can't go search it. So what do you guys do? You just read the next sentence.
You take the door off.
Take the door. There's no chainsaw handy, right? So you got to take the hinges off. That's what you know when you don't have a chainsaw. All right. Show of hands. Good? No good? Good? No good? One of you no goods. Tell the goods why you're right and they're wrong. Why is it no good? You had your hand.
No, why is it? Because if he said he had stuff down there, he admitted he had stuff down there, right?
Right.
So that was my reason for saying
That is
we're good.
That is good. Okay.
Yeah.
Because he basically admits to a probation violation.
Well, I mean, he said he had stuff down there. I mean, he's renting it, but he says, well, I have stuff down there. So I guess I would think that we would be able to.
Who said no good?
But
Why is she wrong? Point at her when you say it.
that is the renter's home, and they have that authority that to deny you entry to their home. Like that. That's what I. And we can get a warrant to enter the place.
Can you get a warrant? What's the standard for getting a warrant? Probable cause, right? So is it more likely than not? You're going to be able to sell a judge on that, right? But you may not have to, right? If you think. So anybody swayed one way or the other? Anybody want to pitch in before I tell you who's right and who's wrong?
So I'm gonna say that's a common area. He admits that he's got stuff in that basement, which would indicate that he has access.
Because it's his house. Right?
Well, whose name is on the lease? Whose name is on the lease?
That's a good question. I don't know.
But he
This
says
is
he
all his
rented it.
space. He's renting it. It's going to be his name on the lease.
Right, then
He's
you
renting
rent
it, it's not a common area.
Yeah.
If he's renting that space,
He
it's
admitted
somebody
to
else.
keeping stuff in the basement,
Yes.
including
Yeah.
a gun safe. So he's admitting that he has access.
He's
to
admitting
that.
he's admitting that he keeps stuff down there. He's not admitting he has access. And that's kind of where the court came down. And for those of you who said we lose, you're right. We lost the evidence in this. It's not good. For what you were saying, it's a renter type. This isn't like his kid. Yeah, he keeps stuff down there, but you know what? And again, remember expectation of privacy. The basement has no expectation of privacy, right? Basement itself, that structure has none. None of the house doesn't. It's the people who live there, right? So who lives in the basement? The renters. Have they done anything to objectively show you that they have an interest in keeping what's in their basement private? What'd they do? They locked it with a number pad. And that's what
admitted to having illegal substances down
and admitted to having illegal substances down there, which is why you can go get your warrant.
there. But by the time
But
we go get a
consent-
warrant, it's gonna be.
Have somebody sit on the house.
Somebody sits there and
Somebody
watches it carried
We're
out.
allowed to do that.
You're with.
Call CBD or somebody.
Probation officers and local law.
Yeah. But as it relates to the consent, why we lost this is because we used consent of the probationer of Andre, where he had no authority legally to consent. Even though he keeps stuff down there, he never said he had access, and in fact, he said he didn't even know the number. Tricky. It's a tough one. tough one. And I give you this one because it is, but one reason I gave it to you is to show you how you still need to understand, you need to be able to step back. It's easy to say, I've got consent all the time, and I don't need to know about emergency circumstance, I don't need to know about plain view, I don't need to know about searching, I don't need to know any of this stuff. Turns out there are times where it serves you very well to know these things. And so that's what this case does. It kind of shows you how you can walk into a situation where you have to step back and look at it as a Fourth Amendment question, as opposed to a strict probation or consent general conditions question. Does that make sense? And also to show you that sometimes, I didn't look on this, I don't know if this is a majority opinion. You know, this could have been a 5-4 decision. There could be 4 justices who agree with you. You know, it's just the way it works. So whatever the judge says is what's reasonable at any given time, whether it relates to consent or any of these other things we've talked about. All right. I think that's probably good enough for me. I'm probably already going too far, so I will hand this over. Like I said, there's some other things on here I'm not going to burden you with, but I believe these PowerPoints will be available to you. And I give you my numbers at the front of the PowerPoint. You know, that's my personal super duper self smartphone number. So if you guys want to, you guys know how to get a hold of me. Most of you do. Call me. I'm used to getting calls from sheriff's deputies, police, all time, day or night. They call silly stuff. And if you want to call or have a question, I'm certainly available for that, as is either of these two gentlemen, I'm sure. So I'm going to hand it off to Jason. Scott's going to start. Oh, Scott. I lied. I'm going to hand it off to Scott.
Do a little state law. First thing I'm going to talk to you about, Jason will cover some of the constitutional issues as it relates to excessive force. That's probably the area where you guys, if you ever got sued, would be most likely to get sued. The first thing that I'll explain to you is that I don't know, a lot of people don't really appreciate the difference in our office between our civil division and our criminal division. I am purely a civil lawyer. I've never prosecuted a crime. I've never appeared in court on a criminal charge. All that Jason and I do and the other people in our unit is handle civil matters. We are actually litigation attorneys. We are the ones that would represent you if you did get sued. We're analogous to insurance defense lawyers if you've ever been sued for a car accident or anything related to your homeowner's policy. Again, that's all we do. We represent every Franklin County agency and employee in that regard. And I'm going to cover with you initially some of the state law issues that go along with that. The first thing I'd note is by statute, the county has to provide you a defense if you're ever sued. All right, that requirement applies to providing you with an attorney, who would be us, and also providing litigation expenses, things like expert witnesses or deposition costs, things like that, which can get pretty substantial. The other requirement by statute is that the county has to pay any damages or any judgment that would ever be rendered against you if you ever were liable for something. Dan already hit on this, and I kind of saved this for the end last time. I've been doing this for 6 or 7 years now for the county. I've yet to represent a probation officer for any case, so you guys don't get sued very often, which is a good thing, obviously, and I'm sure you do a great job, and that's a part of it. But if you ever did, we would have your back, of course. We would be here for you to answer your questions, lead you through the whole process. I'll tell you up front that if you ever did get sued, it's not a quick process. You know, most of our cases take 3 or 4 years to conclude, sometimes longer than that. If you got sued in state court, for instance, you don't get a trial court. The trial court sets a trial date that's at least a year or 15 months out. Usually those get continued. Most of our cases are in federal court. I've got some right now. I've got one that has been going since 2011. So they can last quite a long time, but that's what we're here for, to lead you through that process. The only exceptions, or exception to the coverage that I just talked about, would be for punitive damages. Again, no guarantees, but I've been doing this for a while, and I've never seen a punitive damage award rendered against one of our clients. So it's a possibility. I always tell people about it just because it is out there, but I don't think it's something as a practical matter that most of you would ever have to worry about. But if that ever were an issue, it's not something the county would cover. That's also by statute. That's not just a choice of the county. State law says that we can't cover that. The prerequisites, though, for obtaining the coverage are pretty straightforward. They're that you act in good faith and that you're not manifestly outside the scope of employment or official responsibilities. Those are, again, legal jargon, as Dan said, but they do have a pretty straightforward common sense meaning, in my opinion. They're factual determinations, both of them. And again, both of those have to be met in order for you to be entitled to a defense. I'll talk about good faith very quickly. It's legally, it's honesty or lawfulness in belief or purpose, being faithful to your duties. Dan stole my thunder on this one. What I would tell you is that it's doing the right things for the right reasons. If you're acting as a probation officer, carrying out your official duties, it doesn't mean you can't make a mistake. That's not what this means at all. It means as long as you're acting sort of in your official capacity, doing the right things, you're gonna be fine. It's the opposite of bad faith, which is a legal term that gets thrown around a lot. And I always tell people the legal definition is dishonest purpose or conscious wrongdoing. It means doing bad things for the wrong reasons. If you're going after someone in your capacity as a probation officer in a vindictive way, trying to get back at someone, doing something that's clearly irresponsible, that's bad faith. Manifestly outside the scope of employment. Manifestly means plainly and obviously. Scope of employment means acting, in my opinion, as it relates to you guys, acting as a probation officer on work-related or official matters related to being a probation officer. So if you're acting within your job responsibilities, acting as a probation officer as opposed to acting as a private citizen, you're gonna be fine. Scope of employment does not equal personal or non-employment related matters. So again, the critical sort of question there, if you want to call it that, is are you acting as a probation officer or are you doing something that every private citizen does? If you get in a car accident as a probation officer while you're at work, while you're doing your duties, you'll be covered. If you get in an accident while you're taking your kids to McDonald's on Saturday morning, obviously the county will not cover you for that. Are you acting in your employer's interest? It's common sense. The factors that you think probably would apply do apply. Are you acting within or outside of work hours? Are you acting within or outside of your work responsibilities? Is it a professional or personal in nature? Are you acting criminally or not? These are the factors that are considered. I have the example up there of, you get in an altercation or you use force on someone to effectuate an arrest versus using force on someone to get them to repay borrowed money or over a parking space. Obviously, one is much different than the other. The first situation would be covered, those latter situations would not. During a home visit, you get into it with someone when you have to effectuate the arrest, or do you get in an altercation while at the mall with someone? And the only thing I'd sort of expand on that is, even if it's a probationer, these distinctions apply. So if you're effectuating the arrest of somebody during your official duties because they violated probation, that's one thing. If it's some jerk probationer that you don't like that you see at the mall and you decide to go ahead and give them a rough time, that would be outside of your scope of employment. That wouldn't be something done in good faith. Not saying anyone would do that, just an example.
What if they came at you because you're a probation officer?
That would be, you'd be fine.
Okay.
And, if somebody would attack you in that regard, you should be okay. That's a general sort of question with a general sort of answer. There's all kinds of specific facts there that could apply. But yeah, if one of your probationers attacks you in your capacity, first of all, they probably wouldn't sue you since they're attacking you, but if they did, we'd have your back. I'll also say this. This is a lot of material on this issue. I tell you guys this just because I figure you probably haven't heard most of this before, but 99% of the time, we cover all county employees and agencies when they get sued. We are not looking for reasons not to cover you. We're not looking for reasons to deny you a defense or an attorney. It's just the opposite. I can tell you there have been cases where we call it cutting people off, where we have cut people off from coverage and attorneys, but they're rare. And again, it's not something that we go into the evaluation trying to look for it. It's just the opposite. We're trying to find reasons to cover you. We want to provide you that coverage and an attorney. If there's any issue, we usually get wind of a lawsuit in a number of ways. We'll get a demand letter, we'll get a complaint in the mail, whatever. You guys might get served with something. I would note very quickly, if you ever do get legal process, anything from a court with your name on it, please contact our division, me or Jason or anybody else, and get it to us as soon as you can. But at any rate, with the determination, it's usually made early. It's before or shortly after suit is filed. We don't delay it. It would be a joint determination between our office and your office, and the conduct at issue, the conduct for which you're being sued, would be examined. If you're cut off, if there were a problem, we wouldn't let that linger and let you kind of drift in the wind. We'd let you know as soon as possible, and you'd be responsible for your own defense. Now again, that very rarely happens. I can give you some examples of when the two examples I know of in Franklin County. I was only involved in one of these when there was no coverage. The first would be the penis sandwich incident at the jail. I don't know if anybody heard about that or knows anything about it. There were a couple of deputies who were serving lunch and decided to play a practical joke where they took a bologna sandwich, had one inmate put his penis between the two slices of bread, took a picture of it, served it to another inmate, and then showed him the picture. They thought it was hilarious. I'm sure a lot of sixth graders agreed with them. We cut them off. You know, that's clearly outside the scope of employment. That's bad faith. That's malicious, whatever you want to call it. It's definitely not done in good faith. It's not something that you would do as part of effectuating your official responsibilities. And even though they were at work at the time, they're outside the scope of employment. It's also a good way to ruin some perfectly good bologna and white bread. It's just not what you're looking for. We actually got sued by one of those deputies to try to force us to provide coverage for him. He got a couple of lawyers to sue us over that. We won that case. He tried to make the argument that it was within the scope of employment because he serves meals as part of every shift. So he's just serving another meal, no big deal. The court didn't agree with him. They thought that it kind of went beyond your normal bologna sandwich. They also tried to cite a culture of practical joking at the jail, which I think is, you know, that sort of stuff happens at every workplace, but the court felt that it went way beyond sort of normal practical joking, if there is such a thing. The court agreed with us when we pointed out a lot of evidence that, hey, even though there might be practical joking, we want these people acting as professionals, and we were cracking down on that, and people were getting in trouble for it. But, so that's one instance. Now, this next one I was involved in, we had an assault at the jail of a supervisor against an inmate. The inmate was a mentally ill guy in an isolation cell. They were doing rounds, and they found out that he had a aerosol can in his cell somehow, which is contraband, so they went in to get it. When they went in to get it, he wouldn't come out of the cell. He actually had a sheet over himself. He had the toilet clogged and some other stuff, so they get a team together to get him out of the cell. When they go in, they pull the sheet off of him. He immediately spits a huge loogie right in the face of the supervisor. So they restrain him, get him in cuffs, they get him out of the cell. This is all concluded. The rest of it's caught on video. They're leading the guy down the hallway. He's got a spit hood on. His hands are bound behind his back with handcuffs, and he's naked from the waist down. It's probably 3 to 5 minutes after the initial altercation when the supervisor gets the big giant loogie spit in his face. So when they're bringing him out of the isolation cell, they're down at the main jail. They take him to the visitation booths. They'll use those sometimes as temporary holding cells and just stick him in there for a second while they either clean his cell or figure out what's going on. So 2 subordinates stick the guy in the holding cell. Again, it's after they've got him restrained, they've got a spit hood on him, he's in the cell. The supervisor, who's obviously justifiably fired up about all this, and who, from my understanding, never had any previous incidents like this and was a really good guy. He, you know, I'm sure stewed about it. The stuff's all over his face. He's thinking about it, but the guy's already restrained. He orders the subordinates to open the visitation cell. He gets at the guy while the guy's still in handcuffs and with the spit hood and just starts cranking on his face, punching him in the face multiple times. That guy was also cut off. I mean, he was fired because of that incident. They found he violated multiple policies. The confrontation was completely over at that point, and it was very clear that he went outside of the lines and went after this guy for retribution. So those are the only 2 instances that I know about recently where we've cut anyone off. Other examples from other cases not involving our county would be family or personal disputes. There are some cases out there from other jurisdictions in Ohio where police officers in uniform or in their patrol car, they go to a family member's house, get in a fight with their brother-in-law, or they go home and get in a domestic with their wife, and then they get sued over it. Of course, that would be something that we wouldn't cover. That's a purely personal dispute. Just having your uniform on or having that authority doesn't mean that you're in the scope of employment. And then sexual harassment claims. There's actually been a couple of cases where higher-ups have been not so kind in their actions to their subordinates and have sexually harassed some of their subordinates, but they nonetheless seek coverage once those subordinates sue them, and that's not something we would ever cover for anybody. So that's basically it for me, unless anybody has any questions about state law coverage. I promise you it's not as daunting as it sounds. We're really not looking to cut you guys off. This is what Jason and I and the other people in our unit do every day. If something ever happened, we would be there for you. We'd lead you through the process. And we know you guys have a hard job to do. We represent every agency in the county, from everything from car accidents to excessive force claims in the jail to death cases involving all of the above. I think we do a pretty good job. We're really responsive, and we have a pretty open communication policy, so if you ever do have any questions with this stuff, please give me a call. Thanks.
All right, guys. I'm Jason Wagner. I get the coveted last spot in a 2-hour legal presentation, so bear with me and try to stay awake. Like Scott, I work in the litigation section of the civil division of our office. We have a 3-person team there. We are here to have your back, as Scott said. Moving on past that, one other thing that came up during the last presentation, just to clarify as well, we represent you guys when you get sued. If you ever have an incident at work that leads to an administrative proceeding or HR or something that's more handled in-house, we don't have any involvement with that. But if you do get sued, we're your guys. I'm going to talk to you a little bit about torts. Kind of a weird word, sounds like a bakery item or something, but it's basically, criminal law, you have crimes, civil law, you have torts. These are things that you get sued over. So it's a private or civil wrong or injury other than a breach of contract, duty owed to a standard of care with failing to meet that standard, thereby causing a loss, damage, or injury to another. Long story short, it's a lawsuit. So we have state law torts and we have federal law. We handle both. If you guys were ever to get sued, it's very possible that you could see claims arising out of both state law and federal law. We handle more federal cases. Those are going to be exclusively in the jurisdiction of federal courts. However, if you have something mixed of state law and federal law, the plaintiff might bring that in the state court, and in that instance we would try to remove it to the federal court because we tend to get more favorable treatment. Those federal judges are a little more keen on those federal law issues, so we prefer to have that be where we hear those cases. We'll start with state law torts. While there's going to be many similarities between these, there's also many distinct differences. First, we have negligence. That's probably the most run-of-the-mill tort that you would be familiar with. And as in your capacity as probation officers, you are immune from negligence claims, and we will get more to that. But that's, you screw up, you make a mistake. Most of your fender benders or running a red light, those sorts of things are going to be negligence claims. Then we have intentional torts. Assault and battery, and that IIED is an intentional infliction of emotional distress. Those are probably the most common intentional torts that may be brought against you as probation officers. A couple other ones that we have listed there: abuse of process, malicious prosecution, conspiracy, false arrest. Those are possible causes of action that could come against you. But we're going to focus a little bit more on those first two because we do tend to see those more often, especially in these excessive force, use of force type of cases. Wrongful death and survivorship, they're very similar causes of action. They both involve when someone has died. The wrongful death is brought by the relatives or the next of kin of the deceased individual, whereas a survivorship claim is actually brought in the capacity of the deceased person. So someone, let's say, they suffer an injury, they have a period of 48 hours where they're suffering or they're hospitalized, whatever they suffered during that time period, a suit can be brought in survivorship for those damages. And then a loss of consortium claim, that's a claim that's brought by a spouse or children based on the relationship with the deceased person. So, generally this is based off of, it should be based off of your actual relationship with the person, how close you were, loss of enjoyment of time together and activities that you did together. But generally, even if you have a strained relationship and don't see them that often, sometimes a loss of consortium claim can still survive and have some merit. So state law immunity for you guys. Regardless of the elements of the above claims, you are immune pursuant to state law unless, one, you act outside the scope of employment. So this would kind of go hand in hand with what Scott was talking about earlier, some of the instances where we may not be able to cover you because you are clearly acting outside the scope of your employment. You acted with a malicious purpose and bad faith or in a wanton or reckless manner, or civil liability is imposed by statute. Almost always, if you get sued under state law, those words, malicious purpose, bad faith, wanton, and reckless, those are going to be included in the complaint because any savvy plaintiff's attorney knows that they're going to have to demonstrate that that happened if they want to try to get past immunity. The third one, the civil liability imposed by statute, we don't run into very often at all. And it's not even, there could be a duty imposed upon you by statute. Maybe you have to take a certain standard of care or you have to do something. But unless the statute actually says you can be held civilly liable if you screw up on this, then they can't meet that third standard. So again, we don't see that met. I don't know, I've never seen it met, but Scott's been here longer and we don't really run into that.
Bonds for public offices.
Yeah, bonds for public offices, there's maybe a few rare instances where that applies. Now there are exceptions to immunity, as we just addressed, but the outside the scope of employment, some of the facts and factors that are considered, if it falls into that exception, not sure on that slide when it leads into the next one, but if you, basically the things that Scott talked about earlier, you know, you have to look at the context of how the action was taken. You know, if you're driving your car during one of your job duties versus if you're out on an errand, a personal errand, those two instances are going to be treated differently. Sometimes we had some questions in the last session that tried to break it down by like, well, if I'm driving my work car, is that the be-all, end-all of meaning I'm acting inside the scope of my employment? But the inquiry doesn't end there. You have to look at other factors to see what you're actually doing. Are you doing something in the furtherance of your employment or not? Again, I already touched that second point there. Regarding malicious purpose, bad faith, wanton, or reckless. Again, those words are always going to be included in the complaint if you're sued. Malice is a willful and intentional design to do injury through unjustified or unlawful conduct. Bad faith, acting with a dishonest purpose, engaging in conscious wrongdoing, acting with an ulterior motive, acting out of retribution or to punish an individual. And then those last two, wanton and reckless, you almost see them side by side all the time. It's kind of one of those things that lawyers and legislators like to do where they put two almost identical words together because it sounds better when they're together. But wanton, acting with perversity, knowing that harm is probable. Reckless, conscious disregard of known or obvious risk of harm. But kind of just undercut against all of that, more or less what Scott said earlier is true. If you're doing the right things for the right reasons, you're not going to have to worry about these exceptions applying. So, you know, stick to your standards, stick to your policies, and generally, 99% of the time, you're not going to be acting in one of these realms. The use of force context, this would mean applying force not for defense or to effect arrest, but for the purpose of injuring. So the classic example of this is if someone is not resisting, but they're mouthing off to you, and you decide to use some extra force, you know, pin them down, put a knee in their back, do something that is not necessary to actually effect an arrest or to detain someone, but you're doing it for some ulterior purpose. And also, once that need to restrain someone passes, then you have to use restraint, and you can't give any payback for what's been inflicted on you. The example that he gave of the supervisor in the jail is a good example of this. Sure, the force that was used at the time that guy was spitting and resisting, all that force is justified. But the minute that ceased to be a problem, then you can no longer use force that's not necessary. Can't use it for punishment or retribution. Again, doing the wrong thing for the wrong reasons. If you're trying to injure someone deliberately, that's gonna get you in trouble, and you're probably not going to be able to have immunity in those situations. Doesn't mean that you have to be nice. If you're caught in the heat of the moment, using some choice words against an individual, that in and of itself is not going to, remove immunity for you. It may be, using the buzzwords that Dan used earlier, it may be considered in the totality of the circumstances, but that in and of itself is not going to be something that removes immunity, state law immunity from you. So these standards mean you cannot be individually liable for negligence. So these simple mistakes, we're talking about fender benders, a mistaken judgment, failures to realize something that's not apparent or obvious, or even failure to follow a policy alone are not enough. A lot of times with our clients, they get a little bit cagey, a little antsy when we first start talking to them when they get sued, because they realize that they might have made a mistake at work, and they think that because they haven't followed policy to a T, or they did something wrong, that they're going to be on the hook for liability. But that's generally not the case. You usually are still going to be able to keep your immunity as long as that conduct isn't too egregious. Courts have held that a failure to identify oneself as law enforcement equates to negligence, as does a failure to follow a single policy. So those are just a couple of examples of things that are not going to meet that willful, wanton, reckless, or malicious behavior. Case and fact specific. That means that you can't just, as Dan said earlier, draw a bright line for how this applies. You have to look at the context of the situation. So at the early stages of litigation, and when I say early stages, that could be a couple years even, but pretty much all up until trial, until you're before a jury, the court has to be inclined to believe the plaintiff's version of events. And that's just how our system is set up. It's plaintiff friendly at that point. So if you tell two different stories, some people might think, oh, well, a court is going to believe a law enforcement officer, probation officer, police officer, whatever, is going to believe their version of events more likely than the plaintiff, but that's not the case. The court is legally bound to give more credence to the plaintiff's version of events in those early stages. So, if you are faced with a lawsuit and you see a lot of things in there that you say, oh, this doesn't make any sense to me, and your immediate urge might be, I need to speak out, I need to say this is my version of events. We'll get there eventually. What we first try to do is say, with the version of events that plaintiff has given us, can we get you out of the case with those facts first? And if we can't, then we move along and then we start to unravel what really went down from your perspective. So the court's going to consider the reasons for using force, a type of force, the need for force, and then the events preceding the use of force. All those things are very important for the court's evaluation. One of the big problems that we see in litigation is that officers tend to enhance their stories after litigation. So suddenly the stakes are a little higher, you're not in the heat of the moment, and you tend to embellish the facts a little bit. This gets back to what Dan was talking about earlier about how when you take action, when you use force, sure, in the heat of the moment, you're going to have to act quickly, but you need to be able to articulate why you're using that force. And any statements that you're giving immediately after that, anything that's going to be of record, anything that's on a video or a recording, you need to be able to articulate why you did what you did. And the reason why we want to do that is because if later on you're taking a deposition when we're 3 years down the road in the middle of litigation and you want to add some facts in there that you didn't articulate earlier, that opens a window for the plaintiff's attorney to come in and say, look, he has two conflicting stories. This person's dishonest. We can't give them much believability here. Yeah, evidence of verbal abuse can be problems. Using threats, shut up or you're going to jail, using racial slurs, things that are kind of indicative that maybe the force you're using has a bit of a personal motivation or retribution type quality to it. Those are going to be problems. So try to maintain your composure and use the force necessary in a calculated manner. Rough arrest despite no resistance, that's obviously going to be a problem. If an individual's not putting up a fight and you're roughing them up, that could land you in some hot water. Using force when the need is resolved. Again, once that threat passes, you can no longer use that force. Bottom line is using force to effectuate arrest or defend oneself is different than using force to silence someone or because of irritation. While that threat is there, know why you're using the force, be able to articulate it, and don't go beyond it. Talk real quickly about car accidents. It's kind of boring, but it's something that we see a lot of because there's a lot of Franklin County employees who drive cars. And so same immunity standards apply. Individual liability for negligence will not happen, but the county could be held liable. And again, those same exceptions, if it was malicious, wanton, or reckless, again, then that immunity is going to go away. Things that you look at for the wanton and reckless components, in particular, the speed, the care that was used while approaching intersections, the manner of driving, all those things are going to be considered. County can be held liable, as I just said, though, for your negligence. So those two things are parsed out separately. An emergency call, meaning a call to duty, constitutes a full defense. Where we most often see this is with the sheriff's office, where cars are responding with lights and sirens to a situation. But that's not the only situation where it applies. Lights and sirens don't need to be running. It's what really matters is are you attending to a call to duty? Are you doing something that's work related that you need to get to? That is really the main consideration there. So, however, if there's willful or wanton, again, those same caveats apply. If you're acting in a malicious way, maybe if you're responding to a call of duty, but you see someone that you really don't like, so you decide to pull off the road and try to maybe scare them off the sidewalk. Things like that are not going to fly. This is more so the bulk of what our office handles are the federal claims, and probably what you guys are most likely to be sued on if you were to be sued for anything. And I'll piggyback with what Scott and Dan have already said, which is I think you guys must do a good job at what you do because we don't get lawsuits. And in general, in researching these issues, probation officers generally don't run into a lot of these issues, but the opportunity is there. So we want to make sure that we handle these issues with you now. A lot of them deal with knowledge that you have and knowing what a reasonable officer should do. So by having these talks with you now, it can help prevent some of these federal claims from coming against you later. 42 USC 1983, we generally call those a 1983 action. It's a civil lawsuit in federal court, a federal claim for a violation of a constitutional right. Though it's governed by federal law, it can be brought in state or federal court. State law immunity does not apply in these cases. Don't worry, we still have some immunity that could work in your favor, but it is completely separate and distinct from the state law immunity. And in something that's a little bit different from most of your run-of-the-mill lawsuits, you guys might have heard a comparison of like the American rule versus the British rule, or different rules of how attorney fees are handled. Generally in the US, you don't get to shift attorney fees if you lose. So if the plaintiff brings a case and he wins, the loser doesn't have to pay all of the plaintiff's attorney's fees. However, in the context of these federal civil rights claims, that does happen. We only mention this because it can affect the value of a case. It can affect if we're going to settle, if something's been ongoing for 2 years and an attorney's racked up $60,000 in attorney's fees. And you might be saying, whoa, this was just a minor incident. I don't understand how we could be offering anything near that amount of money. That's something that we have to consider. We have to consider if on the off chance that we lose this case, what could we be on the hook for? And those things, you guys wouldn't believe how quickly they build up. It's astronomical. I mean, 6 figures very easily in a lot of cases. So now we're going to get into excessive force issues. They are analyzed under the same amendment that Dan talked to you a lot about, Fourth Amendment seizures. The right of people to be secure in their persons, houses, papers, and effects against unreasonable, again, there's that buzzword that you're going to hear all day, unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and person and things to be seized. The standard here that is going to be used in evaluating use of force cases is objective reasonableness. So again, another one of those phrases, totality of the circumstances. A lot of times as lawyers and as officers, as Dan said, we want these bright lines to kind of guide us. And it can be a little bit frustrating to not get a clear-cut answer of, all right, if X happens, then I have to do Y. And even these cases that we're going to look at, you might want to say, okay, how did the court decide this? How did this come down? Sometimes we might get a little bit more of a definitive answer. Other times we don't. So we have to really just look at the context, and the whole point of this is to not tell you how you should respond, definitively, but the point is to get you thinking about these things so that when the situation presents itself, you already have some of these going around in your head to help you make your decision of how much force you should use. Generally, the courts use 3 different factors when they're evaluating use of force. Sometimes they don't look at any of these factors. Again, it's the totality of the circumstances, but these are the ones that are most generally used. The severity of the crime, the immediate threat to officers or others, whether the suspect is actively resisting or attempting to evade by flight. Again, one factor not determinative, they're considered together. And the objective standard, how it should be applied, is how a reasonable officer would respond in that exact circumstance, at that exact moment. So there shouldn't be an evaluation from the courts of what they call 20/20 hindsight, where you can look back and say, oh, now we see how this panned out, this is how it should have handled. That's not how it should be. But I say that with a little disclaimer. Sometimes the court trips up a little bit and they can't help themselves, and they do look a little bit at some things that I don't think personally were readily apparent at the time. But generally, that's the objective standard, what a reasonable officer would do in that exact situation. And this is a favorable standard. It recognizes the need for split-second judgments, intense, uncertain, and rapidly evolving situations. The court understands that your job doesn't always allow you time to get on a computer and research what kind of force you need to use in a situation. It is a heat of the moment judgment call. Severity of the crime is probably the least important factor, unless there's no crime occurring at all. Then it tends to be pretty important. Which sounds a little counterintuitive at first, but consider this following example. Someone is pulled over for a broken taillight and pulls a gun, versus someone who robs a bank with a gun and is faced out spread eagle when police arrive. The crime itself isn't really going to be much of a good gauge of the force that's necessary in that situation. It's more so what the officer encounters when they actually need to use the force. That's why it falls a little lower on the list of importance. The threat that's posed, I would say this is probably near the peak of what's considered. The history and the background of the arrestee, history of violence or threats to harm self or others, whether they're armed or not. We have the Kung Fu case in here. There's a case actually where an EMT was trying to hook up a patient, a victim, an individual who was having like a diabetic episode and was resisting, and used some force to take the individual down to the ground to effectuate what needed to be done. And because the EMT had handled 6 or so other runs with this particular individual and knew that they were trained as a black belt in Kung Fu, that the court determined that the extra force that was used to bring that person down was more justified considering that extra factor. The size and stature of the arrestee, a 5 foot tall individual is not going to require as much force as a 6'5" individual. So the disposition of the person, are they angry, drunk, compliant, are they agitated? In the context, are they alone in a house versus a crowded mall? Are there innocent civilians standing nearby? Are they in a dangerous area? Do they have access to weapons near them? All of these things, again, go to the totality of the circumstances that they're going to consider. Of course, the arrestee's conduct and behavior, which kind of encompasses all these things. Threat to you, self, or others is all relevant. Encountering someone who looks like they're about to enter a daycare with a weapon is much different than cornering an individual in a dead-end alley. So all that context is relevant to looking at the force that's necessary. So the resistance component, there has to be active resistance to justify your use of force, not concluded resistance. So after an individual is subdued, you have to cease using the force or only use the force that's necessary to maintain that status. Evading arrest is considered, but in relation to the force used and the threat posed. Again, this kind of goes back to that daycare example. Where are they running and what's there? Are they running onto a busy highway and putting motorists in danger? Are they just in the middle of a field with no one around? Are there potential areas where children or innocent bystanders can be? All those things. Then that goes into considering the force that's used. So tackling someone while they're running and shooting someone in the back can both stop a fleeing suspect. But obviously, one is going to be needed only when a significant justification for it is present. If you do have, let's say, a mass shooter sort of situation, shooting someone might be more justified there. Does the fleeing pose a danger? We talked about in the last session the Paris terrorist attacks, where maybe after this individual plowed with that giant truck over a few people and then was driving away, sure, he's fleeing, but we have already seen what his intent to do is there. So that fleeing, I believe, would certainly require substantial force to be used, deadly force, to prevent him from doing further damage. So the state law, we have state law immunity, and federal law, we have qualified immunity for you guys. Qualified immunity is defined under federal law as all but plainly incompetent are those who knowingly violate the law. This is something that is assumed. You have a presumption of qualified immunity, and it is up to the plaintiff to demonstrate why that presumption should be removed. Okay, so it's a strong immunity that you are given. To overcome, the plaintiff must establish that the conduct violates a constitutional right and that the right is clearly established. This is something that can be a little bit tricky. Again, this is part of the reason that we're here today, because we don't expect you guys to be researching federal cases to see what kind of force has been justified. So, but you do have a little bit of that knowledge required of you. You are kind of expected to have a grasp of what force is justified or not. So these things kind of weigh into that. Clearly established is established by previous cases. So rights are clearly established when the contours are sufficiently clear that a reasonable official would understand that what he is doing violates that right. So we're hoping to give you guys some parameters to work with here today to kind of understand what you need to consider. The court's determined by looking at specific facts of the case at hand and not at broad general propositions. The cases that they use can be from the Supreme Court, circuit courts, or state courts. There are literally hundreds, if not thousands, of excessive force cases. So what we kind of try to do is whittle those down a little bit to make them more digestible and give you some general parameters instead of looking at all these hundreds of cases to figure out what's acceptable and what's not. So we'll start with the Brackens case. Just so you guys know, our federal circuit is the Sixth Circuit, so you're going to see a lot of these cases come out of the Sixth Circuit. There's an excessive force 1983 action. Police attempt to stop a van after it's seen in a high drug area, and check reveals a warrant for the driver, high-speed chase, going 90 miles per hour, going the wrong direction on the highway, tried to ram them. The plaintiff passenger tried to call 911 saying he's trapped and can't escape. However, a lot of these facts were lost in translation and were incorrectly relayed to the officers by the dispatcher. So the officers believed that it was the female driver who had actually called and said that she was trapped and couldn't escape. They believed that the female driver called and said that she was scared to death, when in fact it was the male passenger who had said that. They were told for some reason that the occupants were homicidal or suicidal, which was apparently not true. They were told this 5 times. And they were also told that the male had a gun, or had previously had a gun?
Warrant.
Had a gun warrant.
And a gun charge.
And a gun charge, okay. But anyways, the driver exits when the car comes to a stop. The passenger does not exit and is dragged out to the ground with force applied to the head. And this particular passenger, we like to call them eggshell plaintiffs, but they had a particular vulnerability, some sort of bone condition, osteoarthritis or something, that even with the minimal force that was applied, it broke 2 of his bones. The court found that there was no excessive force in this case. Now we have to consider why. Severity of the crime and the threat. This was a dangerous high-speed chase. There were a lot of innocent people that lives were being endangered by the weaving in and out of traffic. They were informed that the individuals were homicidal, that there were warrants, that the female was scared to death, that the individual had a previous handgun charge. It's inaccurate information, but that doesn't matter, because again, we're getting to that objective reasonableness standard. What would a reasonable officer in the position of the officers at that time, being given this information, how would they handle the threat? Officers at the scene had no reason to question the information they were given, no way to know. The mistakes of the dispatchers are not imputed to them. And they did not know that the individuals were actually unarmed. The resistance part of it, but since the individual was not, leaving the vehicle, they were encountering some resistance there. Their use of force was justified. Let's try
Would
this.
the chase itself be viewed as resistance?
Yes. The fact that they were being evasive. Yeah, exactly.
Probably more, the third factor is the evasion resistance, it'd probably be considered into that, but yes.
Yeah.
And it also, whenever you're in a high-speed chase, it sort of goes to the severity of the crime too, because running itself is part of the crime.
Yeah, I don't know either. It's not there. Yeah, and again, going to that sort of fragile plaintiff there, the injuries were rather severe, the broken bones, but they only used enough force to remove and restrain, and the medical condition is what contributed to those injuries. All right, Courtrone versus Murray, again another Sixth Circuit case. State troopers a state trooper rammed a motorcyclist, which is considered deadly force, after a high-speed chase. There were outstanding warrants for this individual for kidnapping, rape, and bail jumping. They were 25 miles per hour over the speed limit, crossing double yellow lines, driving into oncoming traffic. Drivers and pedestrians were present. The trooper did, however, violate policies related to high-speed chases. So this agency had a policy that after a chase goes beyond a certain speed limit or a certain time frame, that they were supposed to end the chase, and he violated that policy and went beyond what the policy set forth. This was not excessive, even though the potential deadly force and the trooper violated the policy. Does anyone want to take a stab at why?
Significant, well, totality of the circumstance, but significant crime. He's putting other people in jeopardy. And also the policy, you can violate your policy and get in trouble for that. That doesn't necessarily mean you're automatically guilty of civil liability.
Yeah, you hit pretty much all those main considerations. I think probably the threats and the threat to the people who were nearby and the attempt to evade was probably the biggest consideration.
But in the speed chase, that you were looking at how fast you're going.
Yeah, right. I mean, if this guy was going 25 miles per hour and evading police in a 25 mile per hour zone, obviously that's not going to be as dangerous, but this guy's speeding very fast with a lot of pedestrians around. There's a substantial danger to the public in that case. Severity of the crime was not even discussed in this case. So, as we mentioned before, sometimes that's not even really relevant to what the court's going to look at. And again, as you just said, a violation of the policy doesn't mean that there's a constitutional violation. So Kent versus Oakland County. Deputies were responding to the death of a father who had a living will that had a do not resuscitate order. The wife had a durable power of attorney, which gave her authority to also order not to resuscitate him. The family, however, did not have the paperwork on hand that demonstrated these things. So the officers were there to help effectuate a transfer with EMTs to a hospital or possibly coroner. This man was dying, pretty much, he was dead. But since these orders were not, the paperwork was not available, they started trying to resuscitate the individual. The man's son, who happened to be a doctor, became very upset, very agitated. He was swearing at officers and paramedics. However, he was backed up with his hands against the wall and standing there basically just yelling. But he wouldn't calm down. Deputies tased him to subdue him. The court decided, is this excessive force? Maybe. It was maybe enough that it should go to trial. Now to explain, again, I know you guys probably want some more bright line answers here. Was it excessive force or not? The reason that we have to give that caveat is because at this point where this court is issuing the decision is the summary judgment stage. It's one of the motions that we file that we say, hey, given all the facts that have come out here that are not in dispute, we are clearly entitled to judgment as a matter of law. And if the court agrees with that, then they will grant summary judgment and the case will end. However, if they don't agree with that, then the case goes on to a trial. And it's up to then a jury to decide what happens. So this case, this is a 2016 case. I don't even know, Scott, do you know if a trial's taken place?
My guess would be they probably settled the case.
Probably, yeah. But the court at least determined that there was definitely a possibility that excessive force was used in this case, such that they did not grant summary judgment, and that the case should move on. Severity of the crime, this is where it is a big factor. There was no crime going on here. So no crime, no arrest, it much severely lessens the need to use force. The threat and resistance that was presented, again, there was none. Sure, the guy was agitated, he was upset, but he wasn't violently thrashing, he wasn't fleeing, avoiding handcuffs, he wasn't attacking officers, nothing like that. He was just upset. Again, impolite language, not calming down, doesn't equate resistance or a threat. So simply because someone's agitated and you want them to calm down doesn't give you grounds to use force. And totality of the circumstances. They're going to look at this in the context of why they were there, what was going on, what they were responding to, what their whole purpose was to be in that home. And for the record, it is clearly established that you cannot tase a non-resistant person. So if you want a bright line for the day, that's probably the one that you can get. Can't tase a non-resistant person. So Harris versus Langley, sort of similar. Son calls 911 because 83-year-old mother has had a stroke. Officers dispatch for a welfare check, and we have this little caveat that again at this stage in litigation we're going on plaintiff's facts because the court has to give their facts more favor than the other side. Plaintiff was invited in, or the plaintiff invited in officers. Officers apparently refused to come in, but then he closed the door and they forced their way in. Body slammed plaintiff, handcuffed, but don't arrest, and they never checked on mom. So apparently mom was still in trouble there. The court considered additional factors such as the relationship between the force used and the need, the plaintiff's injury, which, again, in my opinion, I don't think should really have been much of an inquiry for the court. That's more of one of those hindsight 2020 things, and not really an objective reasonableness. But again, the courts are human. They look at these injuries, and sometimes it's hard to ignore. So they did consider. They look at the severity of the security problem as well as the other three factors that we discussed earlier. The court found that it was excessive and unprovoked. There was requested medical assistance. There was no crime, no threat, no need for force. And it was pretty cut and dry, and I think you probably all could have seen that coming. Just really didn't make much sense of officers' actions there. Brown versus Chapman. A lot of these cases come out of Cleveland. This was a traffic stop for no headlights. After the stop, the arrestee exits the vehicle, puts hands on the trunk. Officers claimed he broke free when they attempted to cuff him. Witnesses said the officer struck him, at which point he broke away to escape blows before turning to face officer. And officers said they warned the arrestee of a taser, but witnesses said that they heard no warning. Officers deployed the taser. The arrestee ran. They tased him again, tackled him to the ground, said that he resisted some more. They tased him again, and eventually handcuffed him. He had some trouble breathing. The officer said, I'll edit it for the camera, who gives an F. He goes limp. He was placed in a patrol car, requested an EMS. He started to deteriorate. The only actions that the officers took is that they rolled down the window a little bit. EMS arrived, and this guy eventually died from excessive tasing, being tased multiple times. The court looked at the effects of the officer's actions, found that, now I know this doesn't apply very much to you guys because I understand you don't carry tasers, but just for, this is sort of a totality of the circumstances sort of thing. They found that the dart mode taser implicated significant Fourth Amendment interests, versus the direct stun. The different stories by officers and witnesses, and we've kind of gone over this. When raised by motion, the court must always believe facts most favorable to plaintiff. The jury, though, they are called the triers of fact. They get to decide who they want to believe. So if a case goes to trial, the jury gets to decide. Severity of the crime. He's driving without headlights and no ID. The court found and weighed against reasonableness of force. Officer said driving while on drugs, but no evidence that there was no evidence that his driving was dangerous, and he was also already stopped at the time. The threat, eyewitnesses said that he was cooperative, facing officers, standing still. There was no immediate threat. Resistance and evading. This one could be construed in different ways, but we're going to give it, again, most favorable to the plaintiff, trying to avoid an injury, standing still. When it comes to qualified immunity, it's clearly established that firing a stun gun at a non-threatening suspect who is not actively resisting arrest was excessive force in violation of the Fourth Amendment. The Jackson case, officers observe a drug deal approach and the suspect runs into a house. Hands near waistband, suspect stops and turns to officers. They tase him. The suspect struggles. They tase him again, tries to bite officers. They punch him. He continues to spit and yell. He prevents EMTs from checking him out. He eventually dies. Court focused on the resistance factor, active resistance versus passive resistance. When was this threat present and when did it cease to exist? Analyze each use of force separately, which is kind of interesting when you look at this. It said the first taser was okay because he wasn't complying. He was involved in a drug sale, and it was reported that he always carried a .38 on him. Second taser could have gone either way. If he was moving in a response to the first taser, that's not okay. But if he was moving because he was pulling his arms away and resisting further, then it was okay. Third taser was okay because it was not apparent that the suspect stopped resisting from the viewpoint of the officers. The punch was okay because he tried to bite officers. So they look at each individual step here, each use of force separately, and look to see whether each one was objectively reasonable. Fourth taser is okay because he kept resisting the handcuffing. And again, this is sort of like a totality of the circumstances thing. It's not going to give you a clear, bright line to how this is going to work. This is an interesting case, Pennington v. Terry. A stun gun was used when an individual attempted to swallow drugs but otherwise was not resisting arrest. No one saw the types of drugs or how much he was trying to swallow. Officers witnessed him place the pills in his mouth, and later the suspect did admit that he was trying to destroy the evidence. They ordered him to spit out multiple times, and he did not comply. The district court found prevention of overdose and destruction of evidence made taser use constitutional. So it's something to keep in mind that not only are we looking at the threat to other people, other bystanders, or the situation, but we're also looking at the threat to the individual themselves. Sixth Circuit has held that you may apply force to neutralize the threat to the suspect himself. They cited cases where plaintiffs who were tased were suicidal, who were fleeing on foot across an interstate, who were pepper sprayed after banging head into glass repeatedly. They also cited cases from different circuits where taser was okayed to get suspect to spit out drugs, and force was okay to preserve evidence, but they cited conflicting cases as well. They cited Sixth Circuit cases allowing warrantless entry of home to preserve evidence, and plaintiff could not actually point to any case law establishing the right to not be tased. So unfortunately, this is kind of one of these situations where we had a long analysis by the court of kind of what they thought was reasonable force and what was not. But they still kind of came down in the middle of the fence. The court stated that though it had recognized valid governmental interest in using force to prevent overdose and to prevent destruction of evidence in other contexts, it had not decided the case analogous to the present. So they said that force is okay in some of these other cases, but not here, which leads us to the conclusion of where do we stand on it. Lack of a Sixth Circuit case law that would put an officer on notice that the conduct is unconstitutional. One could say, does this case put you on notice that that conduct is unconstitutional? Maybe. It certainly should be something that you consider, and I think this is a situation that you could encounter, where you have a probationer who's trying to destroy some drugs when you have a meeting with them. So I would say, basically, since you don't have carry tasers with you, that's probably a good way to start, that you aren't going to be encountered with that exact dilemma. But you should be considering how much force is necessary. And at least the Sixth Circuit has acknowledged that they do see in some cases where the force is necessary and justified to protect that individual's safety. They didn't decide the issue. Or did they? I don't think they did.
Real quick, that case, because it is so important, I think it falls under that clearly established prong. So they didn't decide whether it's a constitutional violation. They just said that no case has clearly established that it is a constitutional violation. And one thing I'd say to that is that case then doesn't really change anything. It's still not clearly established that it's a constitutional violation. My only guess with that is I think the court, knowing that that situation probably is arising more and more, didn't just want to put a rubber stamp on that sort of conduct for every situation going forward. And they're kind of punting it down the road to see how, if they get a future case, how they might handle it in that circumstance. But at least based on that case, at the very least, we can say it's not clearly established that it's unconstitutional to do it. They just didn't say it is constitutional. So, for whatever that's worth.
Those cases that we just went through are kind of the most important ones that I wanted to go through. We have a few things to follow up here on today that I'm going to try to go through rather quickly since we should be wrapping up soon. So if you guys have any questions at the end, feel free to ask them. I'm trying to get through these rather quickly. A failure to intervene claim could come. It's a separate claim against others who are present. So a couple of you are out on a call and one person starts using force. That other person who is with them may have a responsibility to intervene. It requires objectively unreasonable force to have a successful claim for failure to intervene. Must have opportunity and means to prevent the harm from occurring. So knowledge that's happening and time to prevent it, which the court has held is more than just mere seconds. The Kent case that we talked about, the officer present and facing the confrontation, that was the response to the deceased father. Other officers who were present there when they were tasing the distraught son, they heard the warnings and they could have cuffed Kent herself. Whereas in the Pennington case, the one that we just talked about, less than 10 seconds had passed. They cited the car ramming case that we talked about earlier, and the tasing was a single incident, so there wasn't really an opportunity to intervene. Supervisory liability is another one of these sort of vicarious liability things. You're not the one actually using the force, but because of your association, you could face some liability. Factors which could create vicarious liability for a supervisor: the supervisor participated in the activity, directed the activity, or ratified the behavior of the officers, or failed to act against the activity. In other words, it's basically a failure to intervene claim. Does not mean, the key to this is that unlike some other areas of law, there is not automatic liability simply because there's a supervisor who's higher in the chain of command. Force which injures others, this is sort of like incidental results. It's not a seizure, so it's not analyzed under the Fourth Amendment. It's analyzed under the 14th Amendment. And it's something that to succeed on a claim like this, something that must shock the conscience, or the words that they use. Applies to injuries inadvertently inflicted upon innocent third parties while officers are using force to seize a perpetrator. So it's collateral damage, innocents who, you try to shoot the driver, you accidentally shoot the passenger. We're going to talk about a case here soon, Cass, where it's exactly that sort of situation. It's rare, and it's likely to require an extreme act. Oh yeah, in that case, actually, while generally those cases should be analyzed under the 14th Amendment, they actually analyzed the Cass case under the 4th Amendment. Deadly force, 2 situations in which deadly force may be used by law enforcement officers. The suspect poses a threat of serious physical harm to the officers or others, and the suspect threatens the officer with a weapon, or there is probable cause to believe the suspect has committed a crime involving the infliction or threatened infliction of serious physical harm. This Placus case came from one of Dan's slides. There's no requirement for officers to use all feasible alternatives to avoid using deadly force. So you don't have to do some progressive measure of, I'm going to hit you first, tase you next, then shoot you. If deadly force is warranted, you can use it right away. So this Cass case that we just mentioned, the passenger who's not a target was shot and killed after a driver tried to ram 2 police officers. He had already hit the officer who fired. An officer is justified in using deadly force against a driver who objectively appears ready to drive into an officer or bystander with his car. But as a general matter, an officer may not use deadly force once the car moves away, leaving the officer and bystanders in a position of safety. You guys might have seen in the news lately in Texas, they just had an incident where a 15-year-old passenger in a vehicle was shot. Initially, the police officer said, they were driving at us, backing up into us in an aggressive manner. Later it came out, no, they were actually driving away. So initially, you might have thought maybe that use of force was justified, but it appears, no, it was not. They were driving away. That threat had ceased to exist. An officer may continue to fire at a fleeing vehicle even when no one is in the vehicle's direct path, when the officer's prior interactions with the driver suggest that the driver will continue to endanger others with his car. Again, we're talking about the Paris terrorist attack, not the kids in Texas fleeing from getting underages at a party. Focus on the threat, whether the officer reasonably believed others were in danger. Possible violation of policy prohibiting getting in the path or fleeing vehicle did not affect the analysis. Withers versus City of Cleveland, 21-year-old man fatally shot by police in the basement closet. Police were executing a warrant for armed robbery suspect. They get to the basement of the house. There's kind of a small, dark closet down there. They can partially see the man, but they can't see him completely. They had consent to search, by the way, and they can see his arm make a quick movement to raise up. He was unarmed. He ended up being unarmed. They could not see a weapon, but they saw this quick, what we like to call furtive movement. The neighbor overheard officers saying that they told Withers to get down, and they shot him. The court found that there's an issue of fact as to the length of time between the police officer's discovery of the suspect and firing the fatal shot. In other words, was this really just a split-second reaction? They open this closet door, they see him make this quick movement, or was there some time, as the neighbor had said, they heard him shouting warnings at this guy first, and maybe a little bit of time passed where they could have realized that he was not actually holding a weapon. Also, the court found an issue as to whether aggressive hand movement or attempt to comply with, or whether that hand movement was an aggressive hand movement or whether it was an attempt to comply with the officer's orders. They did not analyze the individual factors, they just looked at the totality of the circumstances. Clearly established that the officer may not use deadly force against a suspect unless the officer has probable cause to believe the suspect poses a significant threat of death or serious physical injury to the officer or others. That's true. I only held you 3 minutes extra, guys. If you have any questions for myself, Scott or Dan, we're happy to answer them. I know we also have some cards up here, and we have our contact information on the slides. We talked to Lori. I think we're going to try to get some of these slideshows to you guys if you're interested in having access to them. Are there any questions for anyone? All right, thank you for your time.